Welcome to The Investigators. I'm Vanessa Murphy, investigative reporter at KLAS TV in Las Vegas. Joining me, my colleague, Kyle Paine.
Hello, Vanessa.
Thanks for joining me. And our guest today is Michael Sanft, criminal defense attorney, now representing Duane Keffe D. Davis. Thanks for joining us.
Thank you for having me.
So we have a sort of an introduction with some background of this case. Let's take a look.
For 27 years, the family of Tupac Shakur has been waiting for justice. We are here today to announce the arrest of 60-year-old Duane Keith Davis, a.k.a. Keffe D, for the murder of Tupac Shakur.
He leaned over on the window, we rolled down the window, popped. They would drove on my side, I would pop them.
Since 2019, he's appeared at least 8 separate times in promotion of this book and repeated various versions of these events, all of which he acknowledges that he is, in fact, the person that ordered the death of Mr. Shakur.
They ain't got me, they ain't got no car, they ain't got no gun, they don't have no forensics, they don't got me, they got everybody on video, they got me on video.
You can be charged with a crime whether you're directly involved or whether you're an aid or an abettor.
He's really a good person, he don't even he ain't no bad person.
So, Michael, when you see that, what comes to mind?
Well, that's the whole reason why we're here. Mr. DiGiacomo last week had said something along the lines of, if it wasn't for, Duane Davis publishing a book and doing interviews, then more than likely he would never have been charged with regard to this particular incident. And so as a result, that's why we're here. Obviously, the question is that do they have the evidence to prove beyond reasonable doubt that Duane Davis is responsible for the murder of Tupac Shakur? And
we should let our viewers know you have not been on this case from the start. You're newer to Duane Davis's case. How did that come about?
I was asked, I wasn't following this case at all. I hadn't been paying attention. A friend of mine, another attorney, had reached out and had asked for me to take a look at the case because the previous counsel was withdrawing due to reasons specified in court. I agreed, not really understanding or knowing that this was about Tupac Shakur. But the more I reviewed the file that was presented to me and the information that I had, I became a believer that this is not the type of charge that should have been charged on Duane Davis.
You know that I have spoken to him in jail about a year ago. I want to play some of those interviews. This is a story that had aired, I believe, in March of last year.
Duane Keffe D. Davis insists he was not involved in the murder of rap legend Tupac Shakur.
So were you there that night in that car? What was your role?
No, I wasn't there. I wasn't there at all. No car, nothing. I wasn't even in Vegas. They ain't got no proof I was in Vegas. They ain't got no gun, no car, no KPD, no nothing.
Shakur's murder, an unsolved case since 1996 when he was shot and killed near the Las Vegas Strip. As first reported by the 8 News Now investigators, Metro Police arrested Davis in 2023 after he wrote a book and gave interviews stating he passed the gun to the shooter.
I was just trying to make money.
How much money do you think you made from the book and the interviews?
I'm gonna answer that when I come out.
Davis insisting he'd be released from jail since our first visit with him back in September. Clark County District Court Judge Carly Kearney set his bail at $750,000 with a requirement to know exactly where the money is coming from to make sure Davis wouldn't profit from the case.
I'm an American citizen. They act like I'm guilty before I give the chance. It's not Russia. This ain't Iran. This is wrong.
He claimed he previously made an immunity deal with the federal government.
He violated all my amendments and constitutional rights. I'm never supposed to be put in jail for this. Never.
Well, they're pointing to the interviews and the book.
Oh, man, I didn't that fucking
And during our visit in January, Davis continues to insist he's innocent.
They ain't got me. They ain't got no car. They ain't got no gun. They don't have they don't have no forensics. They don't got me. They got everybody on video. Do they got me on video?
By our visit in February, Davis was also facing charges in connection with this incident in jail.
That dude came try to attack me. I just defend myself.
During each visit from September through as recent as Tuesday, Davis insists he'll soon be a free man.
I ain't no flight risk or no threat to the community.
At the time of his arrest, Davis was living in Henderson, a grandpa by then who had fought cancer. Now he is charged in one of the most notorious murder cases in America.
He's really a good person. He ain't no bad person.
Okay, so these interviews happened, Michael, before you were involved, because I know you would tell your client, do not talk to a reporter.
Say a little less.
That's my guess.
Honestly, I guess the problem is that every client chooses their own path when it comes to how they want to conduct themselves. Of course, advice of counsel is to just don't say anything because it doesn't necessarily help all the time. But they do have the ability to say what they want to say. And, Vanessa, one of my previous cases as well, my client was very outspoken as to her position on things. And that's just the way it is. I don't ever sit there and berate my client's choice to give a statement. I mean, you handle it as it comes along, and that's what we're doing here with Duane Davis's statements. I want to make sure that I'm clear just in terms of what we're doing here today. Obviously, I cannot talk about facts of the case or things that potentially could come out during the course of the trial. I don't want to run afoul of any type of, accusations of trying to influence a jury panel or anything like that. I can answer questions that I think would be appropriate for you in terms of understanding sort of the process, where we're at with the process, what's going to happen next with the process. But in terms of like pitching to you, where we're going with the case and what we believe the facts will show, that's only up to a jury. Once they've been seated and sequestered and they've heard all the evidence, they can make decisions as to what the facts are. I'm not, here to debate that or at least present or argue to anybody with regards to what our defense is in this case.
Well, and we appreciate that, and we respect that, and we appreciate you just coming to sit down with us and talk with us. The case you were referring to, the other case, Michelle Fiore, that's another story, but our paths crossed with that one. And just for some background for our viewers, as I mentioned, those interviews happened about a year ago, more than a year ago. And I had been putting in requests and speaking with Mr. Davis, but he was telling me, let's do like a full sit-down interview where we really talk about this case and, asking me to sort of wait until we did that interview. He said, you will do the first interview with me. And quite frankly, from sitting down with him so many times, I believed him. And then I discovered he ended up doing an interview, I believe, with a network. And it sort of surprised me. So that's how that happened. But again, we appreciate you, Michael, for coming on. Kyle, you wanted to jump in.
Well, 1996, I need not tell you, was a long time ago. Why do you think they're doing it now? Why do you think they're prosecuting him now?
That's the million-dollar question that I think on some level may never be answered. It's not an element to the crime to which Duane Davis has been charged. So, the motivations of the district attorney's office to finally charge this case after 30 years, it's not relevant. Would we all want to know? Sure. But at the end of the day, it's not something that will necessarily be discussed in court unless the court deems it to be relevant. And that's not my job. That's, Judge Kearney's job to call balls and strikes as to what's going to be relevant and presented to the jury. Obviously, we all know what we did on September 7th, 1996. I'm sure Vanessa can tell us exactly where she was, what she was wearing, who she was hanging out with.
What do you mean? I wasn't born
She was at
yet.
recess.
I wasn't born.
There you go. So she was in heaven, and so as a result, she knows exactly where she was at. But I, obviously 30 years is a long time. It's such a interesting fact pattern in terms of how do you prosecute an event that occurred 30 years ago.
But
that's up to the state to do, and that they have that burden to prove to that jury beyond reasonable doubt that they have the evidence to show that.
But witnesses are dead. People are not easily found necessarily after 30 years. The direct evidence isn't readily accessible necessarily. So even though you might not mention it in your day-to-day conversations with the jury, it must be hanging back there somewhere, no? That it's been such a long time?
I think reasonable people would be always asking that question in the back of their minds. It's like, what exactly is it that they have? You had shown the clips earlier of the sheriff as well as the district attorney getting up in a press conference and saying, hey, we got the guy. I've always find that to be very irritating because in essence, it's, instead of saying like, hey, we have an individual, he's a suspect, we'll let the court process work out. We believe we'll have enough evidence, whatever the case is. But instead to get up there and make those declarations that, justice for Tupac's family, blah, blah, blah. My problem with all of it on some level is it's advertising something that's, at the end of the day, I don't think they're going to be able to prove beyond reasonable doubt. And to me, that's, I think, irresponsible on multiple levels when you have an individual charged with this kind of crime that has that kind of notoriety, and you're doing it really just to demonstrate that somehow you're effective with crimes against people in our community, and that's why you should vote for me as district attorney. I think all those things on some level, when you ask the reason why people do certain things, well, it's self-interest. We all have a self-interest. Even I have a self-interest. I just want to feel good at the end of the day that I helped somebody out that I think honestly deserves that sort of help. But other people do certain things, maybe for political reasons. Maybe there was a discussion at some point as to, the fact that, hey, I don't know if I'm going to get reelected. I might be soft on crime. I don't know. Who knows? I just think at the end of the day, when you have those types of press conferences and you're the elected official and you're up there giving a statement to which you're not going to be able to back up, I think on some level, what typically happens then is that you should be held responsible for that. As an attorney, like I said, I'm, this weird position right now where I just want to make sure I don't traverse into an area in which I'm, sort of arguing the facts, which I don't believe I am. But, this is where we get a little bit, because once again, he did publish a book. He did give interviews. I mean, that's not refutable.
Michael, that's there. This is not a got you show, and this is not a got you question, but I hear direct criticism of the DA and the DA's handling of the case. What's that? Where's that coming from?
Well, first of all, it's coming from 25 years of experience doing this kind of work. It's also coming from the fact that I've handled many cases against the district attorney's office, and I'm going to just throw it out there. And you guys can fact check me if you want, but I think I have the most acquittals against the Clark County District Attorney's Office and the most trials. And I don't think there's anybody that's going to refute me on that. The question is, at the end of the day, is whether or not they charge crimes believing that they have it beyond a reasonable doubt, which is what they have informed me before, is that, hey, we won't charge a crime unless we can prove beyond a reasonable doubt. And that's even before they do the preliminary hearing stages of like a preliminary hearing or a grand jury. They're telling me that they won't charge a case unless they can prove beyond reasonable doubt. And I'm just telling you right now, I don't think it. This is not that case. And to me, I think that's irresponsible on some fundamental level. And I think that's a betrayal of the public trust.
We are going to hear from the DA's office shortly after this break. Welcome back. I'm Vanessa Murphy, joined by my colleague Kyle Paine. Our guest is Michael Sanft, who is representing Duane Keffe D. Davis, accused of taking part. How would you say it, Michael? How would you categorize what he's accused of?
I would say the accusation is that Duane Davis is involved in the murder of Tupac Shakur.
Yeah, and we try to be careful because he's not accused of murder. He's accused of taking part in it. So we try in our reporting to be clear because there's a very big difference, in my opinion.
I think I say orchestrating.
Yes.
Yeah.
That's the way we go.
He was, they're saying that he had said, do it, from the backseat of the car, from from the passenger seat of the car, right?
Sure.
But that he didn't pull the trigger
Right.
himself, and the individual accused of pulling the trigger is no longer living.
Right. And in your story, your excellent story that we aired, he said in the interview with someone else a long time ago, if they had come up on my side, I would have shot him. So, that's damning. There's some damning things here.
Sure.
So one question I have, Michael, we're recording this July 8th. It will air several times after. It will live on YouTube, social media. But here we are on July 8th. Do you 100% believe the trial will happen in August?
You know, that's a very funny question because I've been asked that question since the very first day he took over the case. If you speak to anyone that's ever tried a case against me in the district attorney's office, you know that we will be going on August 10th. Okay. So, you know, the problem with this particular case is that, you know, most attorneys by their own playbook will say, oh, I need more time, I need to review discovery, and then nothing ever happens. I mean, the can gets kicked down the road, and so as a result, the client sits in custody. And in this particular case, I mean, honestly, Keffe D should have been tried. His case should have been tried within 6 months of him being arrested. But you know what ends up happening instead? This event occurs where he's in the jail. I believe he's acting in self-defense when some person attacks him, and then he gets convicted of it and is doing time. And all that does is this lends to more time in custody. I, quite honestly, over the years, have seen defendants sort of lose their desire at some point to actually go to trial on the merits of their case. And they get offered deals where they say, okay, well, you know, you've done 3 years. The offer is 4 to 10 years. And so you only have to do 1 more year and then you get out. And in essence, what you're doing is you're putting the defendant in a position where they're thinking like, yeah, you're right. Things have been delayed for 3 years and I can just do 1 more year on a 4 to 10 offer and then I'm out. Oh, I mean, you talk about, that's not justice. That's, you know, playing the game of attrition. You're in there and you're just waiting for the person to wear out, to be in a position where it's like, okay, I'll take something. Now, once again, there are times when I do ask for continuances, but I never advise clients when I first have a case to waive their speedy trial. Why? Because it's a constitutional right. And second of all, I should be ready to go. They're in custody. And if I believe that they should not be in custody, I should do everything in my power to make sure that that person is ready for trial and that I'm ready for trial. Now, there are times, and if you talk to anybody who's ever tried a case against me or judges who I've appeared in front of, I will ask for continuance. But it's only because I have a very articulated reason for it. Meaning, for instance, I have an expert that I want to call. That person is stuck in another trial, some other part of the country, and they can't make it here. That's an articulated reason. But outside of that, no. You should be ready to go to trial when the date is what the date is. And in this particular case, you know, Duane Davis had waived his speedy trial right. And so, of course, the can gets kicked down the road multiple times. When I got the case in April, it was all hands on deck. My firm has done nothing but prepare for this case. We have gone through every shred of discovery on this case, all the documents on this case. What we have received now up to this point is 13,000 pages plus of documentation. A lot of it seems to be duplicative. And once again, we are ready to go. So Duane Davis will get a full defense. There will be no stone unturned in this particular case. And that, I think, should cause some worry to the district attorney's office. They should be sitting there thinking that, hey, you know what? Michael Sanft is ready for this case.
And you brought up a good point about plea deals because with the types of cases we cover, we rarely end up covering a trial because there are so many plea deals here in Clark County. And I've done interviews with different people in the criminal justice system. And the answer I received from the DA's office and even Judge Tiara Jones, now Chief Judge, correct? Yes. That plea deals are a necessary part because there isn't time, there are not enough resources to take every case to trial. So my question would you consider a plea deal because he has been in custody for so long? I mean, you just touched on it, but.
Well, since we're all friends here, let me just explain it this way. I, as an attorney, have a ethical duty to give every offer that the district attorney's office gives to me. So even if I don't like the offer, my duty to my client would be to sit down with Mr. Davis and say, hey, here's the offer from them. Have a conversation, answer his questions, and then he makes the decision, right? I'm not there to influence his decision. I'm there to basically say, hey, here's what you have in front of you, and hopefully you can make an informed decision. And whatever that decision is, I will respect 100% because it's not my life.
And I understand if you can't answer that, but has this happened? Have they offered a deal?
Well, no, first of all, I can't answer that question. But second of all, I think the only offer right now that I think would be the appropriate offer would be to dismiss this case.
Interesting.
Yeah, very interesting. Because at the end of the day, I think that's exactly where it should be.
Let's hear from the district attorney's office. I spoke with Pam Weckerly, who heads the criminal cases at the Clark County District Attorney's Office. Here's what she said. You have a really big case unfolding in your office right now. Duane Davis, Keffe D, accused of taking part in a conspiracy, essentially, which resulted in the murder of Tupac Shakur. Anything you want to say about this case?
Well, for the office, I think it's an important case, but obviously there'll be eyes on it nationwide, not just in Las Vegas. So it's important in that regard, too. The other thing I would say is it's gone on a long time. I mean, the crime was so long ago. So we're hopeful to get a positive resolution to that case now that we're kind of ready to go to trial and we have a trial date in August.
It's tricky because we know that his argument is going to be, well, I was just saying I did that to sell a book.
Yep. Yes.
So a lot of eyes on that one.
Michael, we said before that Vanessa wasn't born when this happened. When we get the jury pool, we'll see that a lot of people weren't around when Tupac was in his heyday and when this rap battle that was going on between these megastars was happening. But isn't that culture context part of the story here, too, that you'll have to kind of explain?
Well, obviously, we want to take that jury back to the night of September 7th, 1996, and all of its elements, right? The fact that it's in Las Vegas, the fact that it's right after a Mike Tyson fight. You know, there's things about that date that would be important for a jury to consider. And of course, that's whatever the evidence will show. In terms of, the gang element to it, in terms of, Crips and Bloods, I think anyone who's lived during that time period, except for Vanessa, would understand the idea that, hey, you know what? It was sort of just a part of our cultural identity. Movies came out during that time period. One of those movies was Colors. There was a rap, I think, by Ice-T on that specific issue. There was, during that time period, a lot of still sort of bubbling under the surface sort of uneasiness, especially in LA with regard to LAPD, the riots that had occurred earlier. You had the O.J. Simpson case and that verdict and what that was analyzed to be a sort of a response to, for instance, during that time period. So you had a lot of things going on during that time period. Obviously, the gang culture would have been one of those things that would have been considered by police officers at the time of the incident that occurred here in this case. And once again, that's all issues that will either come out during the course of the trial or not. For instance, you and I are wearing blue. Vanessa's wearing red. We're not going to talk about that. No secret. But I'm just saying at the end of the day.
No coincidence.
But, once again, those are all things that could be relevant for a jury. I just don't know at this point what the judge would allow or not allow.
Michael, correct me if I'm wrong, but did you sort of take a pause from dealing with criminal cases because you were turned off by what you saw in our criminal justice system?
No.
But maybe yes.
You
mean like in terms of me stopping my criminal practice?
Yeah.
No, it's economics.
Okay.
At some point, the effort and the time you put into a criminal case does not equate to the same level of return as would be in other areas of the law that I was practicing, and my firm was practicing at the time. We created a personal injury boutique firm specifically on litigation. So we take on cases not necessarily to settle right away, but rather to try in court and to maximize the value and the return to the plaintiff, whoever our clients are in that case. So that's what we were doing. That's what I had done since September of last year. And then I got bored, if you want to be serious. But I got bored. So I started traveling.
With all that money?
You know what it is? I mean, money doesn't mean as much as time, right?
Yeah.
I mean, the older you get, the more you realize that time is really the most valuable thing you can never get back. You can make as much money as you want. I mean, whatever. But at the end of the day, that time is the thing. And so, you know, for instance, last year I ran with the Bulls in Spain in July, and people are like, why did you run with the Bulls in Spain in July? I'm like, well, because that's the fastest I'm going to be. This next year, I won't be as fast as it was last year. Do you see what I'm saying? So to me, things like that, events, you know, experiences throughout the world I was doing, and then I just got bored with it. And so, you know, my friend calls me on the phone and says, hey, you know, can you take a look at this case and see if you want to do it? And I had nothing else going on, so I said, sure, why not?
Were you a Tupac fan?
I love Tupac. I can quote you lyrics right now if you want. I don't think they're appropriate for TV, but on the other hand, I think Tupac has been fundamental in our music. You know, last week I was having dinner with a retired professor from BYU, Brigham Young University in Utah. He's 74 years old now, I believe. And he had asked me what case I was working. I told him it was this Tupac case. And he said, oh, Tupac Shakur. And I forget that 30 years ago, this man was 40, younger than me right now. And so as a result, like you forget that during this time period, you know, if you're looking at people that potentially could be on this jury, the age is not that relevant because these are, you know, Tupac, you know, permeated throughout our culture. MTV, for instance, you know, people were into MTV. I would imagine 40-year-olds watched MTV or had their children watch MTV. So to me, Tupac has had a huge impact in our cultural thinking, in our music. He was a super talented poet and lyricist.
Should it take place, it's going to be a good one.
Absolutely. Michael, thanks for joining us.
Sure. Thank you for having me.